Hi, my name is Graham Hayward. I'm Managing Director of Housing Hand. Housing Hand are the leading provider of guarantees to the UK rental market. The conversation today is around the Renters' Rights Act, and that's so relevant for Housing Hand because we help manage the risk of those changes in the rental market. I'm delighted today to be joined by Ryan Heaven.
Hi, I'm Ryan. I'm a consultant solicitor at Woodstock Legal Services, and I deal with all things letting, so hopefully I'm going to be able to answer some questions today.
So in the event that a tenancy has started under the new rules, so if we can fast forward to that place, and it's a student tenancy, and an unfortunate feature of student tenancies is that a number of them want to leave early. How does that happen under the new scenario?
So we're talking about Ground 4A here, and Ground 4A has a number of conditions attached to it, and one of them is called the student test. So that basically comes down to, is the tenant a student or likely to be a student at the start of the tenancy? So whatever happens subsequent to that, then that is irrelevant. You can still use Ground 4A as long as they were a student or likely to be a student at the outset. And I think it's this likely to be thing which I think is going to cause people a lot of concern, because if you're letting to say second year students, they're already a student, I don't think proving that is going to be very difficult at all for a student. But if they are freshers coming in, they may well be able to provide a UCAS or some form of acceptance letter or something like that. I think landlords at least need to be asking for that document so that they can reasonably say this person is likely to become a student. As long as they can reasonably say that, then they can use Ground 4A, even if they drop out during the process.
Yeah, it occurs to me that there's also an obligation on landlords to identify and right to rent, and that right to rent is typically coming in the student form. So that could be another way that they prove that. Yeah,
indeed. So it's one of those. It's a letter from an organisation, isn't it? So it can be part of the right to rent checks if that's something that's required.
Yeah. So there's a transition period that's coming, and what happens in the event that you've got an existing tenancy which, let's say, finishes in August under old rules, if you want, and now new act comes in. What happens to those tenancies in terms of that end date?
I think this is quite an interesting topic, because my broad experience of student lets is that students don't tend to need to be evicted. They usually leave of their own accord in line with their terms. They want to go home, basically, which is understandable. When all the work's done, they'll leave the university accommodation, and that's played out because a lot of student landlords don't currently, as a habit, serve Section 21 notices to end the tenancy at the end of a fixed term. They could do that, and if they're at all concerned about void periods or the tenants not leaving, then they ought to do that, but they don't. And the reason why is because a lot of students just leave. So I certainly expect it to be the case in at least the first few years for this process of serving the Ground A pre-notice, so that's to say you're going to rely on Ground 4A, and then following up with a Ground 4A notice further on through the tenancy. I think all student landlords are going to have to do that just to kind of manage the risk of this unexpected time. But I will expect after a few years have passed, I think complacency is going to creep in. I think a lot of people are just going to stop doing it because the market forces that have always applied will continue to apply. Students won't want to stay in the property for longer than they need to. They'll be aware that they can end the contract earlier if they need to. So in many cases, the students will just leave just as they always have, even if you don't have that kind of finite certain date on the tenancy to say this is the last day. And even though Ground 4A kind of creates that certainty, but I'll also say it kind of doesn't at the same time. It's better than nothing. But I just think a lot of landlords will see that maybe it isn't actually necessary to do it. But like I say, this is a problem for the future. I would not at all be dreaming of any student landlord doing this right now. They need to be serving these things right away. And actually, that probably segues quite nicely into what about tenancies that you've entered into already for 2025 academic year, where you perhaps have entered into that contract more than 6 months before the tenancy start date. This 6 month window is important because that's one of the conditions of using Ground 4A. Fortunately, there is a transitional period which says that 6-month period does not apply to this wave of tenancies. So the 2025-26 academic year is going to be treated slightly differently just because it's new.
It's the following one.
It's a 2026 problem. So in 2026, all these new rules are going to apply, and that 6-month window is going to kick in as well. So that's not nothing to stress you out right now. You don't need to worry about when you are signing the contracts now, but next year that's something to add to your list.
One of the things as Housing Hand we're going to be modifying in our guarantee process is to ensure that HMO tenancies will serve Ground 4A in order to get the cover of the guarantee.
As a condition of it.
Correct.
Yeah, so then you're kind of, again, creating that artificial fixed term.
Exactly right. Working professionals, though, is not like that.
Well, indeed. So Ground 4A only applies to students. So there are other restrictions on it as well. But let's say you can't use it if you're not a student. It's one of those headline features. If you are not a student, you're letting to people who are professionals, in your words, then you do not have an equivalent of Ground 4A. There are other notices. There are other grounds, and the government has not just taken away Section 21. They have given back some grounds for repossession. They've amended some others, and there are a few headline grounds to talk about. So Ground 1, for example, that currently exists. There is already a Ground 1. The difference being in the future is that you don't have to give a pre-notice to use Ground 1. Ground 1, just for clarity, is to do with whether or not the landlord wants to move back into the property, or they have a family member who wants to move back into the property. A lot of landlords may well be able to do that currently, but they might just use Section 21 because it's simpler and easier, simply because it's more common.
But it's more broad things.
Exactly, but in the future, if you're going to use Ground 1, you can only really use it as limited circumstances. Obviously, there is no equivalent of Section 21. There must be some reason. The government's talked about banning no-fault evictions, but Ground 1, where the landlord just wants to move back in, that's not the tenant's fault. So I think there is like a messaging issue here. There are still some no-fault grounds, but the difference is there has to be a reason given. Currently, you can serve a Section 21 notice for no reason at all. The tenant will never understand what the reason is.
I'm sure we're going to get on to some other grounds, or the keynote grounds, if you like. But in that one that you talk about in terms of reoccupying as the landlord, that itself could get misused, and people could go, well, I am going to reoccupy, but then I don't. What happens in those circumstances? Yeah,
you're quite right. So I'm going to touch on Ground 1A because it mirrors Ground 1 in many different ways, but it's probably easy just to wrap it all up in one go. So there are consequences. This ground, Ground 1, the landlord wants to move back in, or their family wants to move into the property, is currently available in Scotland. They've essentially been a guinea pig for this ground already, and it gets to be used there. So what the government's introduced are basically two control mechanisms, and the second one I think is vital. I don't think when this was in the renters' reform, so the Conservatives attempted this, I don't think they had this mechanism in, and I thought it was really important that they did. That there's the local authority enforcement of it. The downside, obviously, is anyone who deals with local authority or has even read a newspaper in the last few years will know, local authorities are under-resourced, understaffed. They cannot police every tenancy that goes on there. So even though the local authority has the ability to recoup some of these fines that they might levy, so they can use it to sustainably enforce things, they can use that money to hire more people who in turn will fine more landlords, non-compliant landlords. That's one mechanism. The best mechanism, I think, is to do the rent repayment order. But by best, I should qualify that. Most effective mechanism for enforcement is a rent repayment order. That gives the individual tenants the ability to claim up to 2 years rent back if they were given a notice, Ground 1, Ground 1A, on grounds that basically didn't apply. The landlord said that they were going to move back into the property, or they said that they were going to sell the property. They didn't actually do that. There's a qualifying period. So basically, if you give this notice, you cannot re-let the property within the length of the notice period, which is 4-month minimum, and then 12 months thereafter. So we're looking at a minimum 16-month period where the landlord cannot re-let the property. That's to stop it being abused. And if they do re-let it, then the landlord can face a serious penalty from the tenants who have, I would say, better access and means and motivation to be policing this kind of stuff. You might keep a Rightmove tab open of the property which meets the metrics of the property you moved from. Check it every so often. If your property that you were evicted from ends up on that portal, then you basically can claim up to 2 years rent back. And why wouldn't you do that?
Absolutely.
So yeah, I think tenants are heavily incentivized to be policing this, because the local authority simply don't have the resources to do it themselves with the best will in the world.
Yeah, interesting motivation. Are there other key grounds you mentioned?
I did touch on ground 1A. So ground 1 is for a landlord wanting to move back into the property or their family. Ground 1A is the landlord wanting to sell the property. Both of those grounds are 4-month notice periods, and they both are covered by this kind of prohibition period, where if you use that ground to evict someone, you can't re-let it for a period afterwards. I believe this ground exists in Scotland, and similarly it's abused. And I will say, from a personal perspective, the wording of the ground simply says that landlord intends to sell the property. The property doesn't need to be on the market. You don't need to have a buyer lined up. You don't need to have instructed an estate agent or even spoken to an estate agent. You just need to have an intention to sell. And I think that is such an easy bar to clear from a landlord. I think so long as the landlord is prepared to stand up in court and say, I intend to sell the property, I can't see why a court wouldn't make an order for possession, because the court and the tenant would not have the ability to kind of infer the landlord's intention. So even if the landlord had done absolutely nothing to progress the sale, as long as they say, I intend to do it, then they'll get that order for possession. It's in many ways stricter than a Section 21 notice currently. So a Section 21 notice comes with all kinds of strings attached to it. You've got so many different compliance things that can go wrong with a Section 21 notice. So if you haven't served those EPCs and gas safety certificates, the right how to rent guides, then your notice could be invalid and you get struck out and you don't get possession. With these new grounds, the landlord just needs to stand up in court and say, I intend to sell, or I intend to move the tenant back in. And then basically, if they don't do that, it's up to the local authority and the tenants to police it. And then they will simply not do that. Tenants will not be aware that they have this.
But they're open to the previous tenant coming back and making a claim.
Yeah, exactly. It's a risk, basically. I've had some landlords just say, well, can I do it? The answer is, yeah, you can put it on the portal, but on your head be it. If you start marketing the property for sale, and in fact there's restrictions on agents facilitating that as well. So agents will need to ask prospective landlords, the last tenants on the property, did you evict them on ground 1 or ground 1A? In which case, you can't re-let it until that prohibition period's over. You can obviously sell it if you're using ground 1A. That's one of the reasons. But you've got to be so careful with how you're using this, and agents need to be careful as well.
Yeah, and in fact, in the housing hand guarantee terms and conditions, this will be one of the features that we have to change to make sure that you're not doing things improperly.
Indeed, everyone's got to adapt to the new reality. There are going to be ways in which you can be caught out that you can't currently be caught out. There's no doubt, even though the government has given some grounds to the landlord, and that's nice of them, they didn't have to do that. There's no doubt that overall the regulatory burden has increased. It's harder for the landlord to do things than it is presently.
And the other headline items in terms of getting occupant or the tenancy completing. So obviously a tenant can give notice, and so these are non-PBSA. So they can give 2 months notice and then the tenancy will finish. Actually, the guarantee also falls away at the same time because the tenancy is finished. There are other ways that the landlord can actually regain occupancy. I understand they're to do with obviously non-payment of rent or antisocial behaviour. You've already mentioned the reoccupancy or repossession by the landlord for their own use.
Yeah, so these are, let's just say, they're basically the same grounds that we currently have. So you can serve notice for rent arrears currently under Section 8. You can serve notice of antisocial behaviour currently under Section 8. Some landlords prefer to use Section 21 even if they can use Section 8. And this is, I think, been one of the main talking points going into it, is that a lot of landlords, if they serve a Section 21 notice, they have a reason for it. They might not use Section 8, or for example with the sale ground 1A, if a landlord wants to sell the property currently, they can't use ground 1A, it doesn't exist. They can use Section 21. So although the landlord doesn't have to provide a reason for Section 21, there really always is one, because why would they suddenly decide to take a rent-paying tenant out of their property for no good reason? They wouldn't do it. But at least now, I guess this is the motivation, is perhaps the tenant understands perhaps why they've been given notice, even if it doesn't change the practical reality, that they have been given notice.
Students have a lot going on in their life,
busy
particularly
people.
for the first year that they're there. Some of them may well forget to give notice when it comes to the end of term.
I think the landlord will need to bear that in mind. So the landlord will, let's say in this scenario, will have served a ground 4A notice. So ultimately, if a tenant leaves in accordance with that, then that's fine. The tenancy comes to an end, no problem at all. We're expecting tenants to give notice in around May, aren't we? Because in line with the end of the academic year, because they don't have any reason to stay. So why would they? Well, that's what we're anticipating. But we can also perhaps anticipate with there no longer being an end date on the contract, tenants might just simply say, oh, I don't know, when do I leave? I might just stay. I mean, there will be a lot of people who don't know what the rules are, particularly in the first year of it. So yeah, you might have tenants who are in the property in August and just say, oh yeah, I was going to leave, I forgot to give notice. Well, first of all, like I said, the landlord should have given the ground 4A notice anyway. But if they didn't, and there's some new tenants who are going to be moving into September and everyone's panicking about it, the best thing to do would just be to kind of agree a surrender, which you can currently do. You don't have to hold the tenants to their whole notice period. You could say, okay, give me 2 months notice, but if that 2 months notice takes you into the next academic year, that's no good.
Right.
You don't want that, do you? So you just have to take it as it comes, really. If you have a tenant who's forgotten to give notice and wants to leave the property in August without giving the full notice period, I think, okay, let them. If it means that you can get that next transition done properly, then it's probably worthwhile, isn't it? Even if kind of they haven't done what they're meant to do.
A bit of planning and a bit of tracking of what's going on and connecting with everybody.
Yeah, exactly. I think there are some landlords out there who will hold out for every last penny, and I think those landlords will find themselves stung in this new scenario, because if that property isn't empty when the new tenants turn up to the door, they could potentially have lost far more money than they've gained by extracting the value out of that old tenant.
Yeah, and they will go on and find other tenancies.
Yeah, I suppose the flip side of this, though, is that if that tenant wants to stay on for the next academic year, then the landlord may well have saved themselves a relet fee. You know, it's not a given that you need to evict every single tenant. It's just that they don't necessarily want to be liable for rent during that summer period when they're not using it.
Yeah, I mean, practically, students tend to move their stuff out of the apartment at the end of the relevant term. Then they remove into either the existing block, many in the same apartments, right, if you're not careful. So yeah, I think you could find, particularly international students, who say that I'm just prepared to go all the way through and continue.
Yeah, always talk of void periods, and you're right, international students in particular, where that moving out, they might not have a local base of operations. They might not be able to just drop it in their mum and dad's garage. Yeah. They may well be tempted to say, okay, I can take this out for a much longer period of time. And we talked about the danger of the void period. What void period? If they stay on,
yes.
You know, it could be beneficial. So
Absolutely.
Yeah, like I say, case by case basis, I think you have to treat this.
We are offering for no fee to the HMO with a student where they've gone through this circumstance. We will be offering a complimentary service where we pay for half of the rent for 3 months, or up to 3 months. And just to clarify, that void is available in the circumstance where they're a housing hand guarantor client. So if there's 3 tenants who are in the property, we will offer that 50% of rent for those that have guarantees previously in place for that tenancy. In the event that some of the tenants that were in that tenancies are not housing hand guarantor clients, then our cover won't be extended to that. So it's only available for the element that is with housing hand guarantees.